नहीं था ब्लैंक चेक किया था ना How are you breaking? When we put It's a oh, the thing. It is not. But
The duration for this round is 1 hour 40 minutes. Each team shall be given 45 minutes to present oral pleadings. An additional 5 minutes shall be reserved for rebuttal and surrebuttal each. The division of the total time allotted to a team shall be at the discretion of the team members. However, each team should speak for at least 20 minutes. Extension of timing shall be at the discretion of the judges. However, the judge may grant an extension not more than 5 minutes per team. In no case the researcher would be allowed to plead. Case compendiums or any other relevant material, if asked, must be presented to the judges. This shall be done by the researcher of the team. The researcher must not submit anything directly to the judge. Relevant documents have to be given through the courtroom master. The commencement of rebuttal and surrebuttal round shall be informed to the teams by the courtroom master. No team is allowed to carry any other electronic devices inside the courtroom for research or any other purposes. No team shall indulge themselves in any act or misconduct in or out of the courtroom, undermining the credibility of the judges, which may lead to immediate disqualification. No feedback will be given to the participants by the judges or the courtroom volunteers.
also see permission to. So, this is Honorable Bench. I am co-counsel and this is my co-counsel, and we are here to represent the plaintiffs, the present case, that is Satner complications. I shall be dealing with issue number 1, 2, and 3, and my co-counsel shall be dealing with number 3 and 4. The counsel seek permission to continue the arguments with the bench and verify the facts. Reverse with the facts. Certainly, sure. Okay. Your Lordship, in the present case, two parties have come into an agreement, that is a plaintiff, Satnet, and the defendants, Global Orbital. They have signed a capacity lease agreement for 10 years. Now, on 4th of February 2024, there was a cyber attack, after which Global Orbital breached its contractual obligations and failed to provide services to Satnet, due to which Satnet has come here to seek relief for the breach of contractual obligations done by Zero. Can you give us the brief of this fact sheet as to what are the issues that have been brought and why? Certainly, Your Worship. In the present matter, 5 issues have been framed for the court. First is whether the High Court has jurisdiction to deal with the matter. Second is whether the cyber attack will constitute as a force majeure event under the capacity lease agreement. Third is whether Global Orbital's negligence will nullify the force majeure defense that has been taken by it. The fourth issue is whether the blackout and the data breach constitute damage under the liability convention, and if so, whether such obligations can be enforced against those parties. And the fifth issue is whether Satnet's claimed losses, including regulatory penalties and third-party litigation costs, are recoverable under the capacity lease agreement and under the applicable agreement. Much obliged. Moving on to the argument, for the first argument, it is submitted that the High Court of Delhi, the commercial wing, has the jurisdiction to entertain this matter. Firstly, I would like to refer your attention towards basics of the moot corporation. Clause 9.4, governing law and jurisdiction. The clause says this agreement shall be governed by the laws of India, and any dispute shall be subject to exclusive jurisdiction of the High Court. Further, as per Commercial Courts Act of 2015, commercial dispute is specified in Section 2, Clause 1, Subclause C. In that, entry 18 contains any agreement for provision of services or any agreement for sale of goods. Therefore, it is a commercial dispute. Further, it is submitted that we are asking for damages above the tune of 1,000 crores. Therefore, it is a commercial dispute as per a specified value. It is over 3 lakh rupees. Further, it is submitted from where the field of this case. Firstly, the jurisdiction was set to 1 crore, but in 2018, an ordinance was passed by the president, in which it said that in order to fulfill the purpose of this Commercial Courts Act, we are setting the jurisdiction from 1 crore to 3 lakhs. Your Lordship, it is argued, it is submitted that in the present case, the parties have entered into an agreement and they have formed a consensus ad idem on all the provisions of the contract. It is explicitly mentioned in the clause that they have bound themselves to come under the jurisdiction of High Court. Therefore, if this clause is not followed, it will go against the intention of parties and it will go against party autonomy principle. Therefore, this clause, which confers exclusive jurisdiction, should be followed in the present case. And since the commercial court has power to take up this matter, since it is a commercial matter, therefore it is submitted that the High Court has jurisdiction to deal with this matter. Now, coming on to the second prong,
Quantum of loss. How much it is?
it is above the tune of 1,000 crores.
How much?
1,000. Above the tune of 1,000 crores.
Learned Counsel, you are referring to section 7 of the Commercial Courts Act 2015. And in your argument, you are referring to the same by invoking the judgment of Guinness World Record versus Sabavi Mangal, right? So can you elaborate the code that how section 7 is coming into picture in this case?
Section 7 is coming into picture because firstly, it is a contractual dispute and it is a commercial dispute because the dispute stems out of contractual obligations and the parties are dealing or contending these issues under the capacity lease agreement. We as plaintiffs are presenting our contentions in light of the contractual obligations that we owe towards each other and that were reflected in the
How
cap-
come Guinness World Records is relevant to your problem?
Uh, First of all, it is relevant to the present case because it explains the jurisprudence. First of all, when the ordinance was not passed, the cases could be transferred to other courts if they were below the specified value. This caused a problem. Therefore, in this section, in this case, the court held that this transfer of cases should not be allowed. Otherwise, it will go against the objective for which the Commercial Courts Act.
You are invoking it here for invoking the commercial court jurisdiction, right?
No, Your Lordship, it is submitted in
I mean, it is referred to your memorial. Para 4. The same test can be observed in the first proviso to section 7 concerning the jurisdiction of the commercial divisions of the High Court. Shall I give you that?
uh, this case, that is given for records, it applied the same test that was given in section 7.
How you are applying that test?
We are
How come section comment section 7 of the said act is relevant to your problem?
Section 7 of the Section 7 of the Commercial Act is relevant to our problem because we are approaching the High Court under its commercial way. We are approaching the High Court.
Can you directly come to the High Court in by section 7?
This act was passed for that. The objective,
If you read section 7, and if I can draw your attention to the statutory provision, it says all suits and applications relating to commercial disputes of a specified value filed in the High Court having ordinary original civil jurisdiction shall be heard and disposed of by the commercial division of the High Court. So when you have the original jurisdiction, then the commercial court will take it up. So first you establish the original jurisdiction and then you will move to section 7. How come you can directly invoke section 7? Please elaborate on that.
certainly, Your Lordship, it is submitted that we have filed a case on the original side of the High Court. Further, it is also
What is the jurisdiction? Under which article or which section you came to the High Court?
under section 6 and 7 of the Commercial Code.
And what I'm asking, under section 7, when you have the original jurisdiction, then it only mentioned that you can take it to the commercial court division. If I can take when you have said you are going into the jurisprudence of the section 7 says, and I quote from the book of Bach, this section pertains only with jurisdiction of commercial divisions High Court. The commercial division of High Court is the trial court and is created only where the High Court has original civil jurisdiction. So first you establish the civil jurisdiction and then you look section 7 clear that
in the present case, the High Court has original civil jurisdiction because first of all, the cause of action arose in India, which would be my second argument. Second from
if the cause of action arose anywhere in India, will it be a good matter for original jurisdiction of the Delhi High Court?
But as per clause 9.4 of the capacity lease agreement, the parties have submitted themselves to the exclusive jurisdiction of the High Court. Therefore, the High Courts have jurisdiction to take up this matter and then send it to the Commission.
Proceed.
Right. Coming to the second form, it is submitted that the cause of action arose in India. I would like to, the council would in the case of Banyan Tree versus AUP, which has been given in page 21, flag 1 of the compendium, the court used the test of purposeful availment in order to bring a foreign entity under its jurisdiction. In that case, the court said that for the purposes of a passing of action or an infringement action, where the plaintiff is not carrying on business within the jurisdiction of court and in absence of a wrong-arm statute, in order to page number again, page number 21, flag 1. In order to satisfy the forum good that it has jurisdiction to entertain the suit, the plaintiff would have to show that a defendant purposefully availed itself of the jurisdiction of the forum good. For this, it would have to be prima facie shown that the nature of activity indulged in by the defendant while the use of the website was with the intention to conclude a commercial transaction. This is the ratio. The general observation made by the court is that by invoking the purposeful availment test, which says that if an entity, if a foreign entity operations are targeted towards India, by using this test, the courts can confer jurisdiction on those foreign parties. Your Lordship, it is submitted that in the present case, in paragraph number 1, it has been explicitly stated that the agreement is between Global Orbital and SATNet, and Global Orbital will provide beaming signals to Indian territory. Therefore, its activity is concerned towards India and is directed towards India. Further, it is earning profits through that activity, and also the effects of cyber attacks were witnessed in India, as has been given in the Law Corporation, because this specific capacity lease agreement was to provide satellite services in those rural areas where it was not possible. Therefore, it is given that since the activity of the foreign entity, that in the present case that is Global Orbital, was directed towards India, it was earning profits through that activity, and the losses have been suffered in the Indian territory. Therefore, there is sufficient cause of action. Therefore, it is submitted that the High Court has jurisdiction to entertain this. Moving on to the second issue.
No, come to 226. Establish how 226 can be invoked in this method.
The Article 226 can be enforced in this matter. It is an inarguendo because Article 226 says that the High Court has power to take up matters which deal with either fundamental rights or other legal rights given in the Constitution. In the present case, the constitutional rights of many Indians and the legal rights to services, satellite services, were derogated in the present case by global order.
For their fundamental rights, you are approaching.
We are not approaching. It is an inarguable argument that even if we didn't approach under Section 7, we could have approached under Section 220, under Article 226.
I wish to understand problem that when you say we could have reached out to the court of law under 226. How?
Because the
Fundamental right of someone else might be, it is still an issue. That whether the fundamental right has been violated or not. Right? It is also one of the issue, whether there had been a breach or not. We'll be coming to that issue later. But the point here is that whether 226 can be invoked or not, establish it and move forward with issue today.
Certainly, Your Worship. It is submitted that in the arguments presented, we are not arguing that we can come under Article 226. We are arguing that in arguendo, the court could have taken jurisdiction under Article 226.
So please move on.
Moving on to the second issue, we'll say whether the cyber attack constitutes as a force majeure event as per the capital release agreement. I shall be establishing this in a three-pronged manner that the cyber attack will not constitute as a force majeure event. Firstly, it is submitted that the cyber attack was foreseeable within the industry and steps could have been taken to prevent it.
Why do you say it was foreseeable?
Your Lordship, in paragraph number 10 and 9, it has been provided that there had been previous complaints by two sovereign nations, India and US, regarding Norway. Their complaints were relating to that Norway conducts certain cyber attack or it orchestrates certain cyber operations on the sovereign nations have approached, the sovereign nations have complained that there were certain cyber attacks which were caused and it is alleged to be caused by Norway. Therefore, there was a well-known perception risk in the industry that cyber attacks are being caused because two sovereign nations have already complained about cyber attack being carried out by Norway, and it was before this cyber attack.
And was it established before?
It was before the cyber attack. It has been given in paragraph 10 that before the cyber attack, India and US have already.
No, they filed a complaint, but like, was it a conclusive evidence that such attack had been carried out, or was it just an allegation?
It is further council submits that in that we also conducted a forensic investigation and we traced
What you conducted?
a forensic investigation and we traced the attack to the servers of Novak.
What made you conduct that forensic investigations?
Because the attack used highly sophisticated malware attacks and the attack used search technology which was which the council would like to plead that we did not did the forensic investigation. Global Orbiter did the forensic investigations and it related to NUFAC. And
You are claiming we are finding as yours.
we are not claiming we are relying on that to
What
establish.
you have done from your part? If there were the attacks were being conducted and you were aware of it that the attacks are being conducted, where there had been periodical reviews from your end on that?
Uh,
There had been periodical reviews, have you submitted the report to the auditor?
the factual matters is action on that. And further, it was not our duty, it was a duty of global auditors to provide us with services and failure to provide with those services breaches their contractual obligation. We were buying those services, we were at the receiving end, we were not giving those services. If global auditor is arguing that if it is a force majeure event, the onus and burden of proof is on global auditor. And it has been said, it has been given in National Hydroelectric Power of the General Electric, in flag 3, page 27, that a party who is saying that there is a force majeure event, the party has to prove that there were certain conditions that led to.
We agree with you, that is there. But if you were to just explore this situation, that the opposite side has given some arguments which go on to prove that a force majeure event was indeed there. Now, if you have to rebut that presumption which they have like been successfully able to raise, how would you rebut that presumption that there was no force majeure conditions being fulfilled?
Certainly, Your Worship, the council would be contending that firstly the event was foreseeable. Therefore, since the event was foreseeable, there was well-known risk in the industry that cyber attacks happen.
Okay, what else?
It was also, I would have argued in issue 3, but for now, I'm saying that there was negligence on part of Global Orbital. Global Orbital, in its own defense, have said that their systems were offline for scheduled maintenance. And it is an undisputed fact, it has become an undisputed fact because they have also agreed that their cybersecurity protocols were offline for scheduled maintenance. And they have been offline for scheduled maintenance for a month. If Global Orbital is operating on such a higher plane and the services it is providing are for the public welfare in India. Therefore, and also it is known that there is foreseeable risk of cyber attack in the industry. Global Orbital should have taken up to industry standards, should have taken a reasonable time to complete the meeting.
Sure. Any other grounds you have to do force majeure? Like no force, non-existence of force majeure?
In paragraph number 12, it has been contended by us that the that the downtime for these redundancies were extended due to budgetary constraints and not technical incompatibility.
So is it stated in the fact somewhere?
It has not been stated in the facts, but it has been stated in the allegations.
Then on what basis these allegations are coming?
No, where is it stated in the fact sheet? Can you just point our attention to that?
In paragraph number 12. We Sartnet have argued,
So this is again an allegation that is there from your part.
but it has been substantiated by Global Orbital Defense. If your lordship might refer to page number 3 of the memorial of the progression fact sheet, it says Global Orbital denies negligence, asserting that in the second point it has said that its decision to take certain cybersecurity systems offline for maintenance was consistent with industrial standards. Therefore, they have themselves agreed that their systems are offline for scheduled maintenance, and it has been given.
Okay. So since you have very less time left, in the interest of time, please move on to the next issue.
We're attending only two issues.
Three. But I have presented arguments of third issue in this answer as well. That there was negligence.
We can have one question on this. On what basis you are alleging the budgetary constraints? And measures in line, who to establish the protocols were not followed?
Because Global Orbital in its defense in page number 3, in point 2, they have themselves says that their cybersecurity systems were offline for scheduled maintenance. And we are saying that the maintenance will take place from January 2022. The attack happened on February 2024. There has been a month since the maintenance has been going on. Therefore, if
So you are presuming budgetary constraints.
we are due to the absence of facts.
Move to the issue.
It is submitted that I would like to just sum up my second issue because I have already. It is said that proper procedure was not followed to invoke the defense of force majeure. In the present case, in clause 4.2 that has been given in page 6 of the factual matrix, the clause says that the affected party or the party that is claiming force majeure must notify the other party within 24 hours of the occurrence and must make best effort to restore service or provide alternate capacity within a reasonable time.
Okay.
In the
Move on to the next issue. So there was no notice that was served.
There was no personal notice sent.
Yeah.
There was
No notice was served, but later on force majeure was being invoked without any notice being served.
Without any notice. There was a
Okay, let's move on. Yes, thanks.
It is submitted that negligence nullifies the defense of force majeure because it was a self-induced frustration. In the case of boosting agencies versus BTC Swami, which is given in page number 44, flag 7, the court said that party whose act or election has caused that event, he cannot take the defense of frustration or force majeure. In the present case, it has been contended that cybersecurity protocols were offline for scheduled maintenance for since a month. Therefore, there were no mitigation efforts.
Were not available for a month. Have you raised that issue? Artery interruption, when the signals or services were not available for a month, have you raised that issue with the defendants?
We were not notified of it. We were not notified that it would be going on scheduled maintenance. And the Moot Corporation is silent on that.
But you got to know.
We got to know after the event happened, after the cyber attack happened. I would just like to take another minute to sum up my issue. It is submitted since certain mitigation efforts were not followed and adequate safeguards approved industry standards were not followed by the auditor. Therefore, there was negligence on part of them, which will nullify
No,
the defense proposal.
But how do you say that there was cyber security redundancy, that they were not maintaining as per industry standards? Because that's an allegation. That's a defense that they are taking, that we have been taking necessary efforts as per industry standards. In spite of that, the cyber security attack happened. So how do you go on to prove that the industry protocols were not being followed?
Certainly, Worship. In the present case, it has been provided. The global orbital has themselves said that their cyber protocols were scheduled for maintenance for more than a month. Now, if global orbital they knew about foreseeable risk in the industry of cyber attacks because there were cyber attacks being conducted in the industry. Therefore, it would have completed and maintained. It should have completed and maintained within a reasonable time. They have took more than a month to complete.
Maybe that's not the question that was to you, Mr. Counsel. The question that we want to have an answer to is, how do you say that the cyber security protocols that were being followed was substandard? How can you say that?
Moot Corporation is silent on that.
No, he's trying to answer. He's saying that the Moot Corporation does not mention that whether the cyber security protocols were up to the mark, but they make an allegation that it was not up to the mark.
We are making an allegation that it was not up to the mark because we are saying that the scheduled maintenance were not completed within a reasonable time. Further,
Again, the maintenance can be for anything. Maintenance may have been happening for non-essential cyber security measures. Maintenance could have been going on for probably hardware, probably the software is intact, which was enough for conducting the.
In furtherance of my brother judge, what is the reasonable time according to you for that? When you don't know for what purpose it was going on, why you are contending again and again that it was not done within a reasonable time?
The factual matter is silent on that. But since they did not do the maintenance, if they had done the maintenance,
We cannot cherry pick the actual matters, right? This is proving our case, we will cherry pick it and we will leave all the other things.
Okay, sir, the idea is already got with time. Two issues are left. Let it just quickly
understand question.
Yes.
See, you are going to self-induced. Can you justify that?
self-induced because since
What is self-induced you mentioned?
because it was self-induced because if the maintenance had been done with a reasonable time, the payload systems would have been segmented. And in the factual matters, it has been given that on 4th of February, when the first attack took place, the first thing that was attacked were the payload systems. Second of all,
Whole thing was induced by other continuum.
if Global Orbital had applied or had conducted and had undertaken certain adequate safety measures, this flag would have not been used.
Sure. Please move on and wrap up 4 and 5.
My co-counsel will be dealing with.
So, Boardmaster, they have got time, this team?
Yes, sir. Speaker 2 has 22 minutes.
So they have
The team has 45
Oh,
minutes.
so, oh, thank you.
Council seeks permission to approach the terms. Highly obliged. Greetings to the honorable bench. I am counsel 2 representing the plaintiffs to the instant case, and I shall be dealing with issues 4 and 5. Issue 4 pertains itself to whether the liability convention is applicable to instant dates. And issue 5 deals with whether the damages as claimed by the plaintiff are recoverable parent under the capacity lease agreement and the applicable law. With regards to issue 4, Your Lordships, as the issue is framed by the Honorable Court goes as thus, whether the blackout and the data breach falls under damage under the liability convention, and if so, whether the liability convention is applicable. If for the convenience of the court, if I may please read Article 1A of the Liability Convention, it reads as thus. For the purpose of this convention, the term damage means loss of life, personal injury, or other impairment of health, or loss of, or damage to property of states or persons, natural or juridic. Your Lordships, it is humbly contended that statutes and conventions are often always speaking variety. There are two schools of thoughts pertaining to this. One is originalism and the second is dynamism. In India and as well as internationally, dynamism is the concept that is referred to by the Honorable. Dynamism suggests that when the language of the statutes is such that it changes with time, because the scenario is changing with time, the phrases and the language used in the written text must be interpreted according to time, which is a principle that has been invoked by this Honorable Court and the Honorable Supreme Court of India across times. Accordingly, Your Lordships, the Council places its reliance on a landmark case of Senior Electric Inspector versus Lakshmi Narayan Chopra. If you may please refer to flag 14 of the compendium.
Before that, can you just give us the context on which you are referring this case laws?
Indeed.
So it would be in fact better for us to understand.
Indeed, Your Lordship. Your Lordship, issue 4 because it deals with whether the term damage under the liability convention includes data breach or not. Since in this case a data breach has occurred, therefore this question has been formulated by this Honorable Court to consider whether it would fall under the liability convention or not.
Okay, so the liability convention says that damage to property of
Indeed.
states or persons.
Indeed.
Okay. Now, do you agree that there is like damage which is caused to a private party
Indeed.
and liability convention is not directly applicable to private parties? So can you just throw some light on that part?
Indeed, Your Lordship.
Yeah.
Your Lordship, while this is the second prong of the argument under this issue, I would address it presently. Essentially, we are not seeking invocation of the liability convention itself, but only the principles of the liability convention. Why? I will tell you why. Across the factual matrix, the term liability convention has not been invoked by the plaintiffs anywhere. It has only been used in 6 instances, all of which either relate to the issue itself or is one of the allegations or is one of the contentions as is taken by the opposite party, saying that the liability convention is not applicable here. But the plaintiffs are not contending for the liability convention to be itself applicable here because it is an obvious fact that under Article 6 and Article 7 and Article 8 of the convention, it is only applicable to state parties, particularly the launching states. I will further substantiate this with cases as I proceed.
So
Launching state, how you are fixing? How we are attaching launching state here?
Your Lordships, the reason for attaching launching states here is because it is specifically provided in Article 7 of the Outer Space Treaty on which this
Correct. But anywhere it's mentioned that launching state was with the launching state.
in this case, it may as well be USA. However, Your Lordships, to clarify your doubt, I understand what you wish to ask. In this case, we are not making the US as a party or we are not asking for compensation from the state, which is why we are, just to clarify, we are not invoking the liability convention. We are only saying that those principles which make a party liable under the liability convention may be invoked here and may be relied upon by this court.
Then let's take you back again to article,
Indeed.
right? And then you have referred to the Honorable Supreme Court of India for interpretation of the statutory provisions. What is the physical damage you are contending in your argument? And how come that physical damage you are contending is fitting under Article 1 of the convention?
Thank you for your question, Your Lordships. Your Lordships, the plaintiff is not contending any physical damage. The plaintiff is contending that the term property under this definition be deemed to include data breach.
But then it will take me to, because you have invoked the Honorable Supreme Court rules of interpretation, then there is a judgment of State and City of Delhi versus Union Period 2018, and I can quote what the judge has said, court has said. In this case, the Supreme Court underscored that the primary rule of interpretation is to give effect to the plain meaning of the word used in a statute.
Indeed,
Plain meaning. But
indeed.
your plain meaning is not taking where you are trying to take us.
I understand your concern, your lordships. However, the plain meaning of the term property may be tangible property or intangible property. And this has been, the meaning of the term property has been expanded over time internationally and nationally, which is why the case of Puttaswamy versus Union of India arose. Taking the data privacy of an individual to the extent of including it under Article 21 of the Injury Constitution. Which is why, your lordships, today we contend that property now includes intangible property as well, which includes data, and therefore data breach may be considered to be included in Article 1A of the Liability.
The first. So data breach, you are saying that yes, that can be included under the liability convention. What about the blackout?
Your lordships, with regard to the blackout as well, it is the blackout which has caused the cyber attacks plus the blackout which has caused the data breach of the citizens. So ultimately, it boils down to whether the data breach falls under property.
No, but it would be a completely different thing than data breach.
Your lordships, I understand your concern.
Data breach is a consequential damage,
In
due to the blackness. But you cannot claim per se that Nagpur itself is famous. It's their problem.
Now, it says that it is damage to property. So, you have brought to our attention that there are some case laws which say that damage to property also includes intangible damage, damage to intangible property. Okay, so we get that. The second part of the issue, whether such obligations can be enforced in a private contractual dispute.
Indeed, your lordship, that brings
If you
me to my
understand.
second argument. Right. Thank you for your question. With regards to this, your lordship, the plaintiff is not invoking the liability convention itself, but is only contending that this court may be pleased to understand the interpretation or include the interpretation under the liability convention when passing its order. Because it is an undisputed law that liability convention is not applicable between private parties and is only applicable between states. And since in this case, the dispute arises from a contractual dispute, the breach of the capacity lease agreement, and not from the liability convention itself, a state cannot be made liable. Therefore,
In your research, could you find some instances, if a claim has to be filed, what is the mechanism of filing a claim? And is there some mechanism by which a private party can also make a claim under liability convention? Like, say, if I am a citizen of a country and then some space object is, space debris comes and falls on my house and my house gets destroyed. So can I file a claim under the liability convention?
your lordships, I do not find an article with regards to that.
No, it's not about you finding it now. In your research,
I could not, your lordships.
so this team could not find out any mechanism being present by which a private party can also raise a complaint or lodge like a compensation claim under the liability convention.
I understand your lordships, but the entire present situation that is arising is only from the capacity lease agreement, and we are proceeding not under the liability convention, but the Indian Contract Act.
No, but again, liability convention, this is again that in the liability convention, probably a claim could have been filed against the perpetrator of the cyber attack, not necessarily the respondent. It could have been filed against the third party also. When the company, the petitioner knows very well that this action is a direct consequence of a third party. There may have been some breaches on the part of the respondent, but necessarily the incident arose due to causes caused by third party which were beyond their control. So in such a case, why was such an alternative not thought of rather than filing a case against the respondent before this court? Why was this mechanism of invoking the liability convention not thought of against the third party? Our basic question on this issue is that.
And the further answer what my brother did is saying, in your arguments, you have placed reliance on liability convention, right?
Indeed.
So when you are placing the reliance on the liability convention, then how come liability convention cannot establish the cause of action? You should establish the cause of action through liability convention.
Your lordships, if I may please answer your question at the first instance. With regards to proceeding at an individual level, we would have had to proceed through the government of India. However, the government of India, jointly with the government of the US, has already filed a complaint before the ITU. And therefore, it is only for our personal losses that we are coming before this Honorable Delhi High Court.
But the question is not really our question. I think on.
In fact, both the questions on the are on value, including money.
So if you have any answer, otherwise you can move on because you are again on a tight time schedule.
Your Lordships, I believe, proceeding before this Honorable Court was only a result of the contractual agreement in which there is a specific clause which says that out of any contractual disputes arising in the instant case, the High Court of Delhi would have the sole jurisdiction in the instant case, which is why this forum exists.
Please proceed.
Hi, Your Lordship.
And
Your Lordship, with regards to your question, we are not relying on the liability convention articles itself, but only on the principles that you may be pleased to rely on them while passing an order in our favor, if at all.
Then we need to have the order of action arising from liability convention. Then only we will be able to invoke it if we have to invoke it. When you are not able to establish the cause of action through liability convention, we are not full enough that we will be invoking it unnecessarily.
I understand your concern, Your Lordship. However, with regards to use of an international convention or treaty, the law in India has been we can either use the doctrine of transformation or the doctrine of incorporation. In India, through times, while there has been a variance of which doctrine to apply, the law now is fairly settled. There are judgments, very recent judgments, which say that now the doctrine of transformation will apply. That means that even if India has not ratified a particular convention but has signed it, it would mean that the convention can be used for interpretation
but
of
why
Indian
do you go so far when the problem itself mentions India is part to the liability convention?
Your Lordship, it only mentions that India is a party, but it has not ratified the convention.
No, sir. No. What?
Sorry, sure.
Your Lordships, within the moot proposition itself, it has mentioned that it is a party to the.
It doesn't say ratified or not ratified. It is silent on that part. It says it is a party, right? So if you go on the like what is existent as of today, India has ratified the liability one.
Indeed, Your Lordship, but there exists no simultaneous domestic law to that effect, while there exists the space law policy. But
That's not needed. That's not needed. But it is a state to state like affair. In a state to state affair, domestic law will not be necessarily enacted in every country.
that is precisely the contention of the plaintiff, Your Lordship. With regards to this, placing reliance on cases like Entertainment Network Limited versus Super Cassette Industries, it has been specifically mentioned precisely the point that you were trying to bring home, that there is no need for specific domestic law to that effect. And since there is no conflict with any other domestic law, this court may please rely on the principles of the liability convention.
See, counsel, basically what we are trying to say that there may have been alternate mechanisms or avenues to seek restitution for the damage that has been suffered by yourself, right? Our specific question is this: if there were alternate remedies available, why were those not preferred rather than this present remedy of approaching us?
Indeed, Your Lordship. One very simple response from my end. If you may please refer to page 6 of the moot proposition. If I may please read it out loud for you.
Please.
There is clause 9.4 between the capacity lease agreement, which states that this agreement shall be governed by the laws of India and any dispute shall be subject to the exclusive jurisdiction of the High Court of Delhi, which is by this honorable.
Yes. But why do we even raise a dispute with them when the cause also of action was caused by a third party? It was not directly caused by the respondents.
Indeed, Your Lordship.
So when you are very well aware that it was a cyber attack, it was caused from the respondent, which led to your damage. So it is not a direct consequence of their actions. So when you know that it is a direct consequence of some other player's actions, why did you not think of invoking the liability convention and getting damages directly from them?
Your Lordships, to distinguish, the plaintiff herein is a private party and is not proceeding from the side of India. India may as well take its own course of action proceeding against the third country, which is Indeed is vested in India, but it is a private party. Your Lordships, India, as stated in the limited fact in the factual matrix, it has been presented that again a complaint has been filed before the IT.
So our question is not that. Our question is this: that why under the liability convention, if like there was some application which was filed, otherwise like if this was the answer that we are simultaneously also exploring our options under the liability convention, that would have been a better answer compared to saying that a private party cannot approach the liability convention. It is factually incorrect. Sir, you see.
It's a registered company in India, no? Right.
Indeed.
So they have every right to approach the government.
Indeed.
Involves a liability company.
Indeed, Your Lordship, it can invoke the government, but in order for the government to invoke it against a third country, it would have been the prerogative of the government. But in our personal capacity and considering our agreement, our contractual agreement with the other party, we have approached the Honorable Court for adequate release under the Indian Contract Act precisely, which is what issue 5 talks
So the
about.
data, suffering of the data, property of governments.
Indeed.
They could have approached the government.
Indeed, Your Lordship. There is nothing in the fact which states that we have not or will not approach the government. However, today, why we stand before this honorable court is to ask for damages which arise from loss of business, reputation loss, and other such losses, and not to ask for damages for data breach, which is the prerogative of which remains the prerogative of the.
So no damages are sought for it.
For data breach, no, Your Lordship.
Commissioner does not want to see any.
Your Lordship.
Commissioner does not have any obligations with the Indian government or their customers to safeguard their data.
Indeed, it does, Your Lordships. But to bring your attention to page number 4 of the moot proposition, it states that we have filed a suit as is provided in the moot proposition, which we must accept, of rupees 1,500 crores in damages for lost business, reputational harm, regulatory penalties, and litigation costs, but not for data breach per se.
Regulatory penalties are again for data breach.
The regulatory penalties, we are seeking for them to indemnify us for the regulatory penalties.
These are again for the data breach which necessarily occurred. So data breach is also part of the damage that has been caused. That's why regulatory penalties, the question will come. Okay, so you may proceed to the next issue in the register.
And your correction, Lordships. Just to summarize in 30 quick seconds with regards to the contentions of the plaintiff for issue 4, it is that the liability convention does within the term property under 1A of the liability convention, it does include data breach. And it is contended that this honorable court may be pleased to apply the principles of the liability convention while passing its relevant. With regards to issue 5 pertains to the recoverability of damages by the plaintiff, which amounts to a total of 1,500 crores. Your Lordships, considering the paucity of time, I would quickly summarize how I shall be dealing with this particular issue. I shall be dealing with it in a three-pronged manner. Firstly, that the damages, the losses that have occurred in direct and have arisen in natural course of events. Secondly, that the chain of causation is established in the instant case. And thirdly, that the reputational damages are indeed recovered. With regards to the losses being direct and arising in the natural course of events, Your Lordships, the jurisprudence is fairly settled, particularly in section 73 of the Indian Contract Act, which states that only direct and not indirect losses may be recovered. And the same is the position as has been adopted by both the parties in its contractual lease agreement. There is a case, if I may please direct your attention to flag number 16 of the compendium. Indeed, Your Lordships. This case is Central Bank of India versus Shanmuga Video. This is a 2024 judgment, Your Lordships. It invokes the principles of Victoria Laundry versus Human Industries and states in the last line, last highlighted paragraph in page number 80, Your Lordships, it suffices that if he had considered the question, he would, as a reasonable man, have concluded that the loss in question was liable to result. The next paragraph reads, nor finally, to make a particular loss recoverable, needed be proved that upon a given state of knowledge, the defendant could foresee that a breach must necessarily result, but it is enough that it was a serious possibility or a real danger. In this case, Your Lordships, considering the nature of activities that Satnet, the plaintiff, undertakes, the plaintiff takes the services provided by the defendant not for its personal use, but it is one of the only 2 licensed companies in the Indian market which provides broadband services to other markets. With regards to para 1 as stated in the moot proposition, it states that Satellite is responsible for catering primarily to undeserved rural and remote areas. And therefore, your lordships, it is a natural consequence that if there is any breach from their end, it would result in that breach affecting other parties who are contractors or are buying services from us. Which is why, your lordships, in very brief, it is contended that it is indeed a direct loss that arises in the natural course of events and is recovered.
But the basic question here arises is, was there some direct action or inaction on their part, on the part of the respondent?
Indeed, your lordship.
That makes it a direct consequence. But if there is no direct action or inaction, the question of being a direct consequence does not arise.
Indeed, your lordship. If I may please bring your attention to page number 6 of the moot proposition.
Yeah.
Clause 4.2, the second paragraph states, the affected party must notify the other within 24 hours of the occurrence and must make best efforts to restore service and or provide alternate capacity within a reason. You know,
If they are willing to restore all the facilities now, then
indeed, your lordship, however, there has already been a lot of passage of time, and for 26 days, as is specified in the moot proposition, there was a blackout, which resulted in a lot of NEHP loss of data as well, and a lot of effect was caused.
loss of data. Just now you have said breach of data is not your concern.
No, your lordship.
So don't bring in the data again and again.
Understood, your lordship.
Secondly, the same case you have referred to, Victoria Town Livingston. Read the first point of that particular case you are referring to.
Indeed, your lordship.
Again, cherry picking, we are taking the third and fourth
Your
point
lord-
when we are ignoring the first point. The first point in itself is saying that it can be, if the whatever position has been violated, that can be restored, or to that extent, money can restore the positioning. 1,500 crore for the loss of reputation.
if I may please take out 1 moment.
2 minutes.
Highly obliged, highly obliged, your lordship. Your lordship, this recovery of damages is not only for loss of reputation, which indeed has occurred because a 37% decrease in the Bombay Stock Exchange has resulted in the last several days. However, it also results from the other consequent loss of business and the other penalties and third-party litigation that has been filed against the plaintiffs. And furthermore,
Do you have any scheme of thing that how you have reached this 1,500 crore?
your lordships, we have limited ourselves to the motion and there is nothing prohibited. Highly obliged, your lordship. Your lordships, with regards to the first paragraph of Victoria Newman, while it may have been sufficient that if they had provided alternate capacities, and we are open to that now. However, for all the losses that we have undertaken already, we do seek some quantum of damages, even though it may not be exactly quantifiable, but a nearest to that.
How in this issue, the basic question that the bench wants to get an answer to is, are these direct consequential damages which the respondent, again assuming that the respondent had failed in its responsibilities, which led to the causation of the event. Now, are these direct consequential damages, like they entered into an agreement with you to provide some data? If that data is not being provided, they should compensate you and put you on the same level at par, right? But when it comes to third party litigation costs, and those costs can again, like if a person hires a very good counsel, that cost can again be unpredictable. If the case is lodged in some other jurisdiction, again that is unpredictable. Similarly, regulatory penalties, what the government is deciding, that is again unpredictable. The foremost thing that has to be kept in mind is all of this entire chain of events was triggered by a cyber attack, which the respondent claims was beyond their control. If it was beyond their control, the first level of claiming direct damages also from that is again the second level, because it would have been the third party. That's the first level. They are the second level. Now, when you are claiming third party litigation costs and regulatory penalties, that is again third level in the like entire chain of claims that are being lodged. So how do you establish that this is not at the third level, but it is at the first level or the second level?
Thank you.
Because third level is not allowed under Indian law.
Indeed, your lordships. Your lordships, one very simple answer to this, the but-for test. none of this would have been triggered had it not been for their negligence.
No, but they didn't know that there will be a cyber attack happening when the systems are under maintenance.
But even post that, your lordships, they had an obligation to undertake certain mitigative steps which were not undertaken. And as per the clause pointed out earlier, they had to make their best efforts to restore service and or provide alternate capacity within a reasonable time. However, it was not done in those.
Just last question, and then you can go to your question. The damages you are claiming, what is the period for which you are claiming the damages? From which time to which time?
Your lordships, from the time this February 2024, with regards to when this cyber attack occurred, till the time the suit has been filed.
Now, how did you quantify that 1,500 crores?
Could you please repeat your lordship?
How did you quantify that amount loss damages?
Your lordship,
1,500 crores.
indeed, your lordship. Your lordship, while it may not be an exact estimate, however, that is the only calculation that has been provided to this party as per the memorial, as per the moot
So
court.
see, the same amount of time can be given to them.
Just one more thing. Again, if you can go to Victoria Laundry Wilson Limited,
Indeed, your lordship.
para number 2. In the cases of breach of contract, the aggrieved party is only entitled to recover such part of the loss actually resulting as what at the time of the contract reasonably foreseeable as liable to result from the breach.
Indeed, your lordship. As stated earlier, the threshold in this case is that of a reasonable man. If a reasonable man could have presumed that such losses were could have been undertaken due to their breach of the contract, they are indeed recoverable. Linking it to the present case, it was the other party was aware that the plaintiff are the only two licensed companies by the DOT in the market, and irrespective, a breach of the contract to such a level that there was a blackout for 26 days wherein no services were available led to directly causing such damages in our case. Highly regret. Wherefore, in light of the facts of the case, the authorities cited in arguments advanced. It is humbly prayed that this honorable court may be pleased to adjudge and declare that 1. It indeed has the jurisdiction to hear and decide this case. Second, the cyber attack on Aurora 5 does not constitute force majeure under the capacity lease agreement. 3. That the negligence of the other party in maintaining the systems nullifies the defense of force majeure. 5th, that data breach is indeed constituted under damage under the Liability Convention, and the principles of the Liability Convention are applicable here. And 5thly, that the damages of 1,500 crores as claimed by the plaintiffs are recoverable. All of which is moved down. It was an honor after you.
My co-counsel and I appear on behalf of the respondent, Global Orbit, in this case. I will address issues 1, 2, and 3 over the course of 25 minutes, and my co-counsel will take 20 minutes for issues 4 and 5. I could give a brief background of the case, but if your lordships are well, I can proceed with my solutions. Much interest. Your lordships, issue 1 before this court is whether this court has jurisdiction to entertain treaty-based claims against a foreign satellite operator. Now, in this regard, the petitioners have placed reliance, have in fact admitted that this issue under point 4, stating that these conventions do not allow for actions by private parties. But because the issue has been framed as such, I will also deal with that briefly. Before proceeding with countering the submissions of the petitioner, that they have contended that the jurisdiction of this court emanates from clause 9.4 of the contract. Proceeding with the first submission regarding treaty-based claims. The lordships, in my submission, this court does not have jurisdiction to entertain treaty-based claims for 2 reasons. First, that India
This is
follows
what a treaty claim. They claim jurisdiction to the Commercial Courts Act.
That is true, Your Worship, but the issue has been framed as such where it asks us to argue whether this court has jurisdiction to entertain treaty-based claims or not. Only for that limited purpose, I'm making my submission. I will come to the contractual jurisdiction in due course. Your Worships, I have two submissions in this regard. First, that India follows the dualist theory, and second, that even otherwise, the Liability Convention and the Outer Space Treaty contemplate action only between states, contracting states, and not private parties. Coming to my first submission, dualist theory means that even if India has signed and ratified a treaty, for it to be it has to be incorporated into the national law by way of legislation. Article 253 of the Indian Constitution lays down this procedure, which means that the courts
It lays down the procedure on how to frame a domestic law, but it does not mandate that a domestic law has to be framed for every treaty.
Your Worship, if I may,
Is it anywhere in the Indian law? Maybe if it is somewhere there.
indeed, Your Worship. Your Worship, Article 253 reads, if I may read it out for the convenience of this court, legislation for giving effect to international agreements. Notwithstanding anything in the foregoing provisions of this chapter, Parliament has power to make any law for the whole or any part of the territory of India or implementing any treaty, agreement, convention, etc. and so on. Now, this my position has been reiterated in the case of Magan Bhai Ishwar Bhai Patel versus Union of India, which is a 1970 Supreme Court judgment that for implementation of treaties, appropriate domestic legislation has to be passed by the Parliament.
You said treaties cannot be, you can use only with the states. The space treaty and the land. But what is the Article 6 about the space treaties?
Your Worship, this makes me come to my second submission that even otherwise,
But it says that a state has to authorize the private sector. And they are to take international response.
Your Worship, I respect.
System takes response. So automatically the private parties can include.
Your Worship, I respectfully disagree with that interpretation of Article 6. Now, this makes me come to my second submission on this specific point. Article 6 of the treaty, read with General Assembly Resolution 68/74, makes it clear that states are internationally responsible for all space activities, including private sector activities conducted from their jurisdiction. Therefore, this article contemplates state responsibility and not private party responsibility. Similarly, Article 2 of the Liability Convention imposes absolute liability on launching states. Now, launching states has been defined in Article 1, subsection C, as including a state from whose territory or facility a space object was launched. It is evident from these provisions of the treaty and the convention that treaty-based claims cannot be made by private parties.
All the launches are not made by the states alone. Private entities are there only. So how are they fixed by the government?
Your Worship, if you could.
No. States are fixing the private parties to Article 6 only. So they have to give an authorization. When they give an authorization, they would have mentioned all these conditions. So private parties are.
Your Worship, I refer back to Article 6, which again contemplates action, or rather makes only states internationally responsible. This was a conscious choice taken by the states during the formation of this treaty. Therefore, the treaty now mentions for liability on states for their own activities and national activities. Now, national activities in the present case, the treaty is silent on what that means. But the General Assembly Resolution 68/74 clarifies this point that national activities includes activities by private actors as well. And Article 6 contemplates the liability to be between states only, even for actions by private actors from their jurisdiction.
But states can impose the liability claims on behalf of the private companies. See, they can pay the damage costs, but again, they will claim it from the private sector. That's why they are asking for what you call that insurance claims or bank guarantee of that. So if given the authorization, they would have got that. Suppose if 50 crores lost they are drinking, government will pay. But how they will settle it? They will collect it through the private company, through the bank guarantee they have given, or insurance they will give. Indirectly they are connected.
I completely agree with that point, Your Worship. But since this present case is a contractual case, as rightly pointed out by the petitioner, this court cannot provide relief based on treaty conventions. This subsequent action will have to be brought between the government and the relevant party.
Can treaty dispute can't be a contract based dispute?
No, Your Lordship. In the present case, there has to be a distinction needed between.
If there is a dispute that is arising out of a treaty, can't it be a contract based dispute as well simultaneously?
Your Lordship, it certainly can be, but for the purpose of this court's jurisdiction, that claim cannot be adjudicated here. The Liability Convention provides for how such claims are to be taken up.
Haven't in the CLA you have agreed that the jurisdiction will be of the High Court?
Your Lordship, that is true. And
Moreover, I can take you to section 5 of the Delhi Courts Act 1966. And I can read out for you the clause. The High Court of Delhi shall have in respect of the territories for the time being included in the Union Territory of India all such original appellate and other jurisdiction as under the law in force immediately before the appointment so and so. Subsection 2, notwithstanding anything contained in any law for the time being in force, the High Court of Delhi shall have in respect of the said territories ordinary original civil jurisdiction in every suit, the value of which exceeds 2 crore rupees.
Your Worship, I agree with that point, and that I agree that this satisfies the pecuniary jurisdiction of this court. That the subject matter jurisdiction of this court is satisfied because the commercial wing of the High Court has been under the Commercial Courts Act. But my contention on this point is that the territorial jurisdiction of this court under Section 20 of the CPC is not satisfied.
When you are coming to section 20 of CPC, you are talking about cause of action and part performance.
Yes, Your Worship,
I
precise.
can take you to the statement of jurisdiction of your memorial. You are saying section 20 CPC makes clear that jurisdiction that is only where the cause of action arises. And here, no part of performance occurred in Delhi. But the service is not being provided in Delhi.
Your Worship, if I could address this point, this also brings me to my second contention where I'm dealing with their invocation of clause 9.4 to the contract. Now, in my humble submission, this exclusive jurisdiction clause is invalid because party autonomy cannot override inherent lack of jurisdiction.
This you need to have checked at the time of the entering into an agreement.
Your Worship, I agree that that would have been the ideal scenario. But in the present case,
upon it arguing now that it should not have been done. I have taken a step and now I'm regretting that it should not have been taken. Can I avoid the liability in that case? I cannot.
Your Worship, if I may place reliance on the judgment of Rakesh Sharma versus STFC Bank, which lays down 3 conditions for determining the validity of an exclusive jurisdiction clause. The 3 conditions are: firstly, it must comply with section 28 of the contract.
Here it is in your compendium. Page number
Your Lordship, you will find this judgment at page 35, the compendium.
25.
35, Your Lordship.
35.
Yes. Lordship, find this.
But how is this case relevant? Like there may be 4 grounds which the court laid out. Which is relevant for you?
The third, what agree with the first and second promise. The third says that jurisdiction cannot be conferred on a court which otherwise lacks it.
Okay.
Now,
Now, why does it say that it lacks it?
It is my contention that it does not have the territorial jurisdiction under section
Why?
20 of the CPC. Now, under section 20 of the CPC, a cause of action, a suit may be instituted where the cause of action wholly or in part arises.
Only is that the only condition?
The other condition is where the defendant decides. In the
Okay.
present case, the defendant decides.
Okay. Is there some other like factor there in section 20 CPC?
Your Lordship, in my understanding, these are the only 2 conditions based
Cause
on
of
which
action and defendant's resident.
defendant's place of residence or business and where the cause of action wholly or in part arises.
Okay. Now, why do you say that cause of action partly also did not arise in Delhi or in India?
Indeed, Your Lordship. Your Lordship, in this present case, the facts are silent on where the contract was entered into. So before that, the case of ABC Laminate versus AP Agencies has held that in a breach of contract case, the cause of action arises where the contract was entered into or where the contract was to be performed but was breached. in this regard, my submission is that
Now, that is not in section 20. CPC.
that is an interpretation of section 20 of the CPC regarding cause of action
Regarding cause of action.
in contractual disputes.
Correct.
And you'll find this case at page 50 of the compendium.
Yeah.
Now, in this case, it is my submission that the performance of the contract in the alleged breach occurred outside the territorial jurisdiction of this court. And I will demonstrate how. Lordships, under clause 4.1 of the contract, the respondent's obligation is to provide uninterrupted satellite service. Now, if I could broadly demonstrate in technical terms what the active steps required to form this contract are. It requires monitoring and maintaining the satellite. It requires allocating and managing bandwidth. It also requires network architecture and backend integration. Now, these steps are carried out using ground-based infrastructure, such as ground stations, network operation centers, and satellite control systems.
So, when counsel you are referring to the case, in the same case also have a consent. No, we have followed the Hakam Singh case. Isn't it very clearly indicated by the Supreme Court in Hakam Singh case that they will have the jurisdiction if you have agreed upon it?
Your Worship, I understand your concern, but my submission is that party autonomy in this case cannot override mandatory provisions of law. Now, mandatory provisions of law being satisfying the jurisdiction of the court under section 20 of the CPC. If a court inherently lacks jurisdiction, parties cannot, by virtue of an exclusive jurisdiction agreement.
Complete agreement with the plaintiff that the part performance or the damages have been occurred here. It was the people here have suffered.
That's why we want him to explain that why part of the dispute
Is
cannot be
not
said to have been in Delhi. Yeah, please,
Your Worship, if I may come to that.
please.
Your Worship, given that the respondent is located in the United States, and it is my humble submission that it is reasonable to infer that all these ground-based stations are also located in the United States, because it does not require communication with the satellite specifically from a region. Now, by contrast, the
Where
only
the services
component,
were being used.
Your Worship,
No
the
matter
services-
where the satellite was placed, where the services were being provided.
Your Worship, the services were being provided to in India, but my contention is that the only component located in India were the end user terminals. Now, which the entire purpose of these end user terminals is receiving the downlink stream. That's the entire purpose of the end user terminals. Now, therefore,
This agreement was not about services, providing services.
it was regarding provision of services, but it is my contention that this service, in technical terms, was completed when from the satellite, a downlink stream was directed towards the end user terminals. Now, the maintenance and management and installation of these end user terminals is not my client's responsibility under the contract. My client's responsibility, in my humble submission, ends when the downlink stream is transmitted towards the end user terminals, and this concludes at the point of satellite itself. What happens after that downlink stream has been transmitted, it may depend on several reasons like the hardware conditions of the end user terminal, or the weather conditions which may determine what kind of signal strength is there.
Okay, so can you say that these are all part of the same transaction? Why would you say these are not part of the same transaction? Under the Evidence Act, if there are some causal action which happened that resulted into subsequent ripple effect, till the time that ripple action ended, it will all be considered to be one composite transaction. Under that, even the end user's terminal also gets covered in the blackout and in the data breach. Because where did the data breach end? It ended at the user terminal, right? So user terminal would also be considered to be part of the same transaction when the transmission started till the time the transmission ended. How would you argue against that?
Your Lordship, in my humble, I understand your concern. It is my only humble submission that in the limited part of the contract that has been provided to us, my client's responsibility is only limited to providing broadband satellite service. Now, this, as I mentioned earlier, this performing this obligation requires us to only transmit the downlink stream. Beyond that,
Now, again, that have you explain why you wanted this. the entire transaction was always supposed to end at the user terminal since the inception of the contract. Do you agree with me there?
Yes, Your Worship.
Right. Your service, you render a service. Your service rendering obligation ends when it reaches the service recipient, right? Your service recipient is the end user terminal. So unless your signal reaches there, your obligation to provide the service does not end.
Your Worship, I beg to differ on that last point. It is my humble submission before this court that the obligation ends when the downlink stream has been transmitted. Because what happens after that with the downlink stream?
Okay.
Is
Now,
out of our control.
let us take you, the counsel, to the Contract Act. If you see, there are some illustrations in the Indian Contract Act which deal with something close to this. There are examples where it says that a letter has been dispatched. Unless that letter is received, that communication is not deemed to be complete. What does that mean? That basically just means if you are a service provider, if you are supposed to provide electricity, you cannot say that I switched the switch on in my electricity station and there was some wire damage. That's why it did not reach your premises. My obligation is done. You can't say that. Your job is to let the service reach the recipient unless it is agreed otherwise. Had it been said that specifically in the contract that my obligation ends there, which is not the general parlance. In general parlance, we have been entering into and managing such contracts for a long time. That is never the general rule. So arguing that no, this is not part of the causal relation, no part occurred in India. Now, what would you say regarding the blackout? What is blackout? Blackout means the end terminal is not receiving any signals, right? That it is not receiving any signals because of lack at your downlink end. When you are not able to downlink the signal, that's why they are not able to receive it. So how would you say that that is not part of the same transaction? Or like it's not a part of the cause of action in your words?
Your Lordship, I see that Your Lordships are not with me on this point. And in the interest of time, if I may proceed with
No, you may proceed. We can give you, we have the liberty to also provide you additional time. But the point is, how can you are not able to establish that this court does not have jurisdiction. So we can proceed with adjudicating this claim. You are not able to explain or like make us believe in your point that we don't have jurisdiction, we lack jurisdiction. We think we have the jurisdiction.
Your Lordship,
Because you are not able to prove that the cause of action, you take resort to section 20, that the necessary conditions are not fulfilled. But part of the transaction, part of the cause of action happened in India.
Your Lordship, while my contention remains that the point of breach in the present case was at the satellite itself, which is beyond the territorial jurisdiction of.
If a person hinges on one viewpoint and does not want to differ, there is no end to an argument. There can only be an argument where there is logical reception and logical disseminance of a point. But that's not it. Oh, okay, please proceed with the next issue.
Indeed, Your Lordship. Your Lordship's issue 2 before this court is whether the cyber attack on Aurora 5 constitutes a force majeure event in the contract. Now, if I may just, before proceeding with this submission, I may clarify how this is distinguishable from issue 3, so that the scope of my submissions would be considered accordingly. Issue 3 for this court is whether Global Orbiter's alleged negligence in maintaining cybersecurity redundancies nullifies its force majeure defense. Now, here, issue 2 deals about post force majeure event obligations, and issue 3 deals with pre force majeure event obligations. And that is what the structure of my submissions would be. Now, under the Indian Contract Act, Section 56 deals with frustration of contract. But Supreme Court has held in the case of Satyavata Ghosh versus Munjiram Bangar, which can be found at page 64 of the compendium, that this section does not apply if 2 conditions are fulfilled. First, that the contract contains a force majeure clause, and second, that the event claimed to be force majeure is contemplated in such clause. In such case, it has been held that this is a contingent contract under Section 32, and Section 56 finds no application. Now, if I may invite your attention to page 4 of the case record, which is the force majeure clause in the contract. And if I may read it out for the convenience of the court.
Sure.
Your Lordship, it reads, Clause 4.2 of the CLA contained a force majeure provision, excusing liability for non-performance caused by events beyond a party's reasonable control, including malicious cyber attacks by state and non-state actors. It is evident that this clause clearly contemplates cyber attacks within the ambit of force majeure. In such case, it is well settled in Indian law that the obligations of the parties subsequent to the force majeure event are exclusively governed by this contract and not the Indian Contract Act section.
Now, can you again bring to our attention, were you referring to the fact sheet or the memorial? Page 4, you said?
Your Lordship, page 4 of the case record, the fact sheet, contains the force majeure clause.
Page 4, which
Sorry, para 4 of the case record. Para 4 at page 1. The last line mentions cyber attacks by state and non-state actors.
Right.
Therefore, it is my submission that cyber attack was contemplated by the parties as a force majeure event. And therefore, the obligations subsequent to happening of a force majeure event, because this is a contingent contract, are governed exclusively by the contractual terms and not the contract.
okay, but it says it excuses liability for non-performance caused by events beyond the party's reasonable control. The petitioners rightfully bring to our attention that there has been a maintenance that went on for months altogether, or probably a month, and there were some redundancies, there were some substandard protocols being followed when it comes to cyber security. How are you going to answer to such claims?
Your Lordship, this is what is specifically covered under issue 3 of the issues that have been claimed.
So that is redundant, cyber redundancy.
Right. So these refer to the events that happened before the force majeure event.
Yeah.
Which is what I clarified earlier, is covered under issue 3. Issue 2 deals with the obligations post the force majeure event. What happened after the cyber attack happened.
Now, whatever it is, issue 2 or issue 3, you give us an answer to our query.
Your Lordship, in that case, I will move to issue 3 and deal with
Wherever
specific-
you just
First move to issue 3, then we will come back to
India.
Sure, sure.
Your Lordship, the Supreme Court of India has held in DLF versus Capital.
No, we want it from the facts. You leave the cases, you refer to the case law later. First, give us some clarity on the facts.
Indeed, Your Lordship. Your Lordship, I have 2 reasons on why my client was not negligent. First is that the cybersecurity protocols were offline because of maintenance, which is consistent with industry standards. Now, what these industry standards entail is something that is not explained further or detailed in the case record. However, my second reason is that even if it is considered that these were offline for any other reason but not maintenance, it is my humble submission that the attack was that even if they were offline, this cyber attack could not have been prevented. I say this because the attack was sophisticated and state-sponsored, and the scale of the attack was enough to bypass any cybersecurity system.
Is it written that it was state-sponsored?
Yes, Your Lordship.
Which part of the topic can you bring to our attention?
Your Lordship, if I may invite your attention to para 90, para 80 of the case record.
But where does it mention that it was state-sponsored? Two more minutes.
Can I have a
Two more minutes you have. Your time is already up. You say it is state-sponsored. We don't find it in the problem. That is why we need your help.
Your Lordship, if I may refer your Lordship to para 19, it states that the ITU has received a joint complaint from India and the US alleging harmful interference to Aurora 5 and requesting coordination measures against Norva, who has refused cooperation, claiming lack of evidence.
Yeah, so that does not give any suggestion that it was state-sponsored.
Your Lordship.
It says that there is no evidence. Norway says the cyber attack being claimed from our sovereign jurisdiction. We have no evidence to that effect. That does not say it is sponsored by Norway.
Your Lordship, if I may also invite your Lordship attention to para 10 of the case record, which states that the forensic investigation, which was also shared with SATNet, traced the intrusion of the IP addresses to Norway. Which is a third country having history of alleged state-sponsored and state-sponsored
History again.
cyber attack operations.
This is like we can't, as a court, we can't take lightly when you put an allegation saying that some state integrity associated with some non like state activities. So this does not say that. It may have had a history. The IP address may be traced to that country, but we cannot say that if any IP address is traced in India, then the Indian government is behind that.
Your Lordship, I understand your concern, and if I may,
Let's go on to the next issue. Or like you have got something else to say in this issue?
Your Lordship, my only submission in this regard is that this scale of the attack was such that even if my clients may not have maintained the cybersecurity, if my client had maintained the cybersecurity protocol, nothing could have been done to prevent it because the scale of the cyber attack was such.
So that is again a hypothetical situation that you are trying to point out. But had your maintenance not gone on for an extended period, but during the maintenance, the cybersecurity protocols were like in place, that could have been possible. While your maintenance is going on, some alternate system is put into place. And after that, aftermath of the event, the action of not providing alternate capacity, it also points a wrong finger at your client's end. So these are our concerns when we see the case. But you may please proceed to the second or the third.
Same like, and the cybersecurity protocols are being followed, available protocols. But you cannot make a system vulnerable to external threats. You should have sufficient protections. That's the system practice followed by every computer releases.
Your Lordship, my only submission in this regard before I seek permission to move to the previous issue is that as held in DLF versus capital gains, negligence as an exception to force majeure can be claimed only when it is the proximate cause of the non-performance. It is my submission in this case that negligence was not the proximate cause, because even if the cybersecurity systems were online, nothing could have been done to prevent it. Therefore, the causal link between the absence of cybersecurity protocols and the cyber attack is missing. That is my relative submission.
Okay, noted.
Do you think that the possibility of the obligation is still the performance of the obligation is still a possibility?
Your Lordship, if you could complete.
Do you think that the performance of the obligation is still a possibility from your end?
Indeed, Your Lordship, in the present case, after the 26-day blackout, services have been restored.
And on that line, the Honorable Supreme Court in the case of NTPC Limited versus Siemens Limited have already clarified that a contractual force majeure cannot be invoked to avoid obligations where performance is still possible.
Your Lordship, in that respect, if I may take you back to the force majeure clause, in the present case, the force majeure clause clearly contemplates two obligations after
agreed that the performance of the obligation is still possible. You have agreed to that?
Yes, Your Lordship.
The Supreme Court has clarified that where you have a possibility of performance, you cannot invoke the force majeure clause.
Your Lordship, if I may invite your attention to the obligations imposed on my client after a force majeure event. These will be found at para 5 of the case record. Para 5 at page 1. If I may read it out to the convenience of this book. It says, clause 4.2 stated, in the event of a force majeure occurrence, the affected party shall make best efforts to resume or restore services and where possible, provide alternate capacity within a commercially reasonable time. These are the two obligations imposed on my client. And since this is a contingent contract and the force majeure event has happened, the obligations in the present case will be exclusively governed by this clause. And this clause contemplates restoration of service.
At them with the alternate capacity.
Your Lordship, in that regard, while my client had satellites with overlapping coverage, alternate capacity could not be provided for two reasons. Before I move to those reasons, if I may bring your attention back to para 5, it states where possible provide alternate capacity. in this case, it is my submission that it was not possible for two reasons. Those two reasons are firstly, that first was the ITU coordination constraints. Now, under the radio rules of ITU, satellite operators are required to comply with strict rules regarding frequency coordination and orbital slot usage. This means that each satellite system is assigned a specific orbital position and frequency bands which they can use. And these are coordinated internationally to avoid clashes between different frequencies and networks. These regulatory requirements under the ITU and the bureaucracy involved in getting permission to change them is what limited the alternatives that we had and also restricted us from giving any immediate relief to the petition.
Immediate, we are not asking for immediate, it has already been 26 days.
Your Worship, so my second reason on why an alternate capacity could not be provided after the regulatory hurdles under the ITU is the technical incompatibility.
See, performance was not truly impossible, right? Do you agree to that, that the performance of the obligation was not truly impossible?
Your Worship, I will beg to differ in that. In the present case, because of the cyber attack, our capacity and the entire capacity went down. And
You lost the control, but you could regain it.
Indeed, Your Worship. It took us 26 days to regain control, and this is the first obligation, which is to undertake best efforts to restore or resume services. Now, before I move to
Because the same force majeure clause you are referring to again and again in para 5 clause 4.2. So you are taking a part of it, you are trying to assert it on the other party, and you are trying to ignore that part which puts a liability on you, an obligation on you.
Your Lordship, it is my submission that my clients also they were with the first obligation, which is to make best efforts to resume or restore services. In the present case, the blackout lasted 26 days, subsequent to which services were resumed. Now, in the present case,
Now again, services were resumed, you have performed your obligations. Now, as per the case of the case I have referred to, NTPC Limited versus Siemens, you cannot invoke the force majeure clause.
Your Lordship,
Because you have resumed the services, now it is not an impossibility. You cannot enforce the force majeure clause.
Your Lordship, in the present case, because this is a contingent contract, the parties may agree on the outcome of happening of a force majeure event. Now, in the present case, the parties have agreed that in case of temporary force majeures, such as a cyber attack, the obligation on my client would be to make best efforts to restore services. Therefore, the parties have specifically contemplated resuming performance once the force majeure event has subsided. And in this case, this requires two obligations on my client that till the force majeure, like till the resumption of services is possible, alternate capacity be provided, and also take simultaneously best efforts to restore services.
So you are trying to restore the services, but you have not provided with the alternate capacity.
Your Worship, in this regard, my submission is that we have taken best efforts to restore service, and as the force majeure clause states, where possible, it is our duty to provide alternate capacity during that event period of force majeure. And in my submission, there
Force majeure have come to an end, your efforts have also come to an end.
Your Worship, at the end, like, after the 26-day period, since the capacity was restored, there was no more obligation to provide alternate capacity because the primary capacity was restored. The alternate capacity could not be provided for two reasons, which was the ITU constraints and the technical incompatibilities in software.
You can give the concluding remark in 30 seconds and then we will move to the speaker.
Indeed, Your Worship. Your Worships, regarding best efforts, it is only my contention that given the scale of the attack and that the petitioner catered to critical clients in India, it was important to ensure prudence over speed in restoration of services. Therefore, the use of the phrase best efforts must be understood in this context and not in hindsight. That concludes my submission on issue 2 and issue 3 as well. And I urge this court to find that that the force majeure event, the invocation of the force majeure event was valid in the present case, and that there was no negligence, that negligence was not the proximate cause of the non-performance.
Sure.
If I'm of no further assistance to this, I invite my co-counsel. It was an honor argument.
Permission to address that. Am I on? May I please the court? I am counsel for the respondent and I will be addressing issues 4 and 5 before this honorable bench. I shall be speaking for a total of 20 minutes. Issue 4 before this bench is whether the blackout and data breach constitute as damage under the Liability Convention and whether this is enforceable in a private contractual dispute. Your Lordships, a simple submission in this regard is to answer the question in the negative. The Liability Convention does not recognize the alleged blackout and data compromise as damage, and it cannot be enforced in a private contractual dispute. I have a two-pronged submission to make under this issue. Firstly, to prove that the damage caused is not in line with what is envisaged under the Liability Convention. And secondly, to prove that in any case, the convention cannot be enforced against private party. Turning to my first submission, Your Lordships, the definition of damage as given under Article 1A of the Liability Convention includes 4 specific losses. Firstly, loss of life. Secondly, personal injury or other impairment of health. Thirdly, loss of or damage to property of state or of persons. And lastly, property of international intergovernmental organizations. Your Lordships, we submit that this definition is exhaustive and cannot be extended to include intangible or moral harms that the petitioner is seeking from this court today. The definition
It's a well established. And loss of property of state includes the data is supplied to the state. So when there is a breach, the data being supplied to the state, is it not a loss? It's intangible.
Yes, Your Lordship, they did place reliance on Indian jurisprudence to establish that property also includes intangible property, which includes data. However, we submit that as the Liability Convention stands presently, it does not include intangible harm because it only includes physical damage of property. Now,
But when does it say physical damage? It says damage to property or loss of property.
Yes.
It doesn't even differentiate between intangible and tangible
They would
property.
look for the definition of the
Do you have
property.
any cases which can help us reach the conclusion that you want us to reach?
Your Lordship, I have a two-pronged answer to this. Firstly, that since there has been no case under the Liability Convention, I should be relying on certain commentaries to establish that it was physical damage which was contemplated. And secondly, Your Lordships, at the time when the treaty was conceived by states, they had envisaged a situation where there was certain physical property damage caused due to satellites in outer space.
So is there some
Yes, Your Lordships. If you could refer to page 117 of our compendium, I am referring to an commentary by Marco Pedrazi, who is a professor at the University of Milan. He has clearly spoken about how, at the time that the convention was envisaged, it only spoke about physical damage which had a causal link established. Therefore, in the present case,
can you read that book?
Your Lordships, is given under the definition and nature of damage and its compensation. The definitions make it clear that physical damage caused by impact of a space object or possibly by contamination arising out of an impact was chiefly contemplated. What seems to be certain is that the causation link must be sufficient, and the author clearly points out that the discussion is open on whether modalities of causation of damage by a space object other than physical impact, that is, through the emission of radio waves, would be covered.
So that is under discussion, right?
Yes.
It is not negated. It is not negated. They use the word chiefly. Chiefly physical damage. They don't say only physical damage. So you are trying to probably mislead the court when you say that that was what was the intention when the treaty was drafted or ratified. Because we know it for sure that was never the intention at that point of time as well. That is why we wanted you to read it out, what you are quoting. So that does not lead to the conclusion that you suggest. You have any other reference that you can rely on?
Yes, Your Lordship. So, in the case of Cosmos 954, where the Russian satellite did explode in the environmental space of Canada, the Canadian government tried to invoke this very definition of damage to claim for the environmental harm that had been caused due to the nuclear debris. And in that case, the government could ultimately not settle the claims under the liability convention, and it was ultimately settled through diplomatic.
That is not helpful. Because at that point of time also there is no observation by the tribunal that who is at fault or whether this claim can be admitted. They chose to withdraw their case and settle it out of court. That does not lead us to this
And it
conclusion
is
that.
also not clear that why it was not settled in the liability convention.
So you can't take it as a precedent.
Can be because of the.
Yeah, they paid for that. So had it not been paid in the out of court settlement, probably we could have agreed with your conclusion, but that's not the case. Any other authority that you have to your point?
Not at the moment, Your Lordship. It was just, I understand that this court is at the liberty to interpret this definition in various ways. However, it was in my humble submission, the definition presently as it stands without any amendments only covers physical damage. Which brings me to my second submission, that even if for a moment we consider that this court can allow for intangible and moral harms, this cannot be brought in a private contractual dispute in the first place. That is because Article 2 of the Liability Convention, and if I may read it out for this court, a launching state shall be absolutely liable to pay compensation for damage caused by its space object on the surface of the earth or to aircraft flight. This is the punitive provision of the convention and imposes absolute liability on launching states for any damage caused, even if it is to private parties. Further, to answer the question that you had posed to the counsel for the petitioner, the two resolution mechanisms envisaged under the liability convention are firstly diplomatic negotiations under Article 8 and 9, and secondly via a claims function under Article 14 and 15 of the convention. Both of these resolution mechanisms have to be instituted by states to other states only, and in no scenario can a private party invoke this treaty or convention. Therefore, to conclude my submissions under issue 4, since the counsel for petitioner has argued for this court to take the convention into account while giving their judgment, we submit that no reliance can be placed on the liability convention at all, and my client is not liable under this convention towards the petitioner.
Can you please go to Article 12 of the convention?
Yes, sir.
Can you read it out?
The compensation which the launching state shall be liable to pay for damage under this convention shall be determined in accordance with international law and the principles of justice and equity in order to provide such reparation in respect of the damage as will restore the person, natural or juridical, state or international organization on whose behalf the claims presented to the condition which would have existed if the damage had not.
Or will you argue this?
Um,
Of the argument you were presenting?
Your Lordship, the first sentence of this very article states that the compensation will be paid by the launching state. That is not global orbital, but the United States, under which we are registered entities, and where the claim under this convention should be brought in the first place, either through diplomatic relations or via the claims function. If Your Lordships are satisfied with my answer, if I could move to issue 5 before this bench.
Yes, please.
For recoverability of damages, issue 5 before this bench is whether SATNET claimed losses, including regulatory penalties and third-party litigations, are recoverable under the agreement and applicable Indian law. Your Lordships, we submit that SATNET's claimed losses are not recoverable in the present case for 2 reasons. But before I move on to why they're not recoverable, I would just like to point out to this court that SATNET has 2 modes of recovery in the present case. First is under clause 7.1 of the agreement, and second is of unliquidated damages under section 73 of the Contract Act. And I shall, under my submissions, prove that none of these can be recovered by SATNET before this court today. If your lordships do not have any preliminary questions, I shall move to clause 7.1 of the agreement.
7.1?
Your lordships,
Oh, okay.
Yes.
Yeah, we have that. You can please, in fact, you are quoting it already in your memorial at page 18.
yes.
So we can see that. You can please show us why under this claim cannot be made.
Your lordships, if I could just break down the requirements under clause 7.1 for the sake of convenience. Firstly, it obligates the respondent to indemnify the petitioner for all direct losses. Secondly, such direct losses should be caused by the respondent's failure to perform its part of the contract. Thirdly, it excludes failures caused due to force majeure under clause 4.2. And lastly, it explicitly excludes indirect or consequential losses. Our primary contention still remains that the cyber attack would constitute as force majeure under clause 4.2, and we have fulfilled our duties under that. Therefore, our case falls within the exception given under clause 7.1. However, even if this bench is of the opinion that the respondent's actions do not constitute as force majeure, the petitioner is still not entitled to recover damages under clause 7.1 because the losses claimed are not direct. They are consequential and indirect losses that they are claiming before this court today.
Why do you say these are not direct losses?
Your lordship, under clause 7.1, it clearly states that only direct losses can be recovered.
We read this. What basically our question is, why do you say that the losses that are claimed by them are not direct losses?
Your lordship, that is because the chain of causation in the present case is broken by the intervening act of third-party litigators who have chosen to further institute suits before the court against the petitioners. And the losses that they claim today include the litigation costs of PILs, civil suits, regulatory harm, all of which are not direct losses.
Loss of reputation.
Your lordship, even the loss of reputation is a very generic loss that cannot be quantified in the present case, and none of these have materialized or actualized yet before any of the courts today.
You mean to say the whole of the jurisprudence around the defamation is baseless? If the loss of reputation is very generic and it does not mean anything.
No, certainly not, Your Lordship. We are humbly submitting before this court that the only direct loss that has occurred due to our
They could not provide us what was promised to us. Because of it, we could not provide the services. It has led to our reputation. We have suffered. It has led to the falling of our shares in the market. What more direct connect you require to establish your case?
Your Lordship, the services were down for a mere 26 days, after
Here,
which we
26
had,
days. Such a less amount of time.
out of a 10-year lease period, we believe that
We
given,
understand that 26 days will be here and there. Right?
no, Your Lordship. Our submission today is that the direct,
The court can take away your mobile phone or your internet for 26 days, that will be fine. For your lifetime, 26 days is nothing.
certainly not, Your Lordship. That is not what I was trying to establish, but just that we were also under a cyber attack that we could not have preempted either. Therefore, we did our best. We took the best efforts that we could to restore the services, which did take us 26 days.
Cyber attack, you were not preempting. For what purpose maintenance was going on, for what purpose cyber security was commissioned in all your program. If that was not foreseeable and you were not preempting it. Any company, any organization dealing with data, dealing with providing services, can they do not preempt cyber attack? Is there anyone in the whole world who can say that I cannot preempt the cyber attack? Can even, you are a company, right? You're an organization. Can an individual not preempt that I'll be a subject of cyber attack?
Your Lordship, regarding the extent of the cyber attack and what we could have done to prevent it, or the post cyber attack measure that we could have taken. As my co-counsel mentioned, we did take our best efforts to ultimately restore the services, and we ultimately did what was possible from our end to fulfill our duties under the contract. And regarding the recoverability of damages, ultimately,
Why you think it is not?
yes, Your Lordship, my simple answer to that is that the direct effect due to an alleged breach would be the monetary cost of the data lost for 26 days. But that is not what they are claiming today.
What about-
Like, Your Lordship, these are unintended and further ripple effects or the cascading effects that might have been caused because of the cyber attack in the first place. These were not actions by Global Orbital. These were actions by the cyber attack caused in Norway. Therefore,
Is it, what does the book problem say about it?
Your Lordship, just to clarify, the data breach was caused when the malicious code from Norway had exfiltrated the system, which
Your
means
system.
yes, Your Lordship.
And from there, after
It
that,
caused it caused a data leak in the South Asia beat, including India.
right. But the data leak happened from your beat, your satellite. Someone else injected a software. Did not get into that. But how can you say that it is not a direct loss when it is originating from your end? Our question is that had it like after the hack happened, after that there was some aftermath, it did not originate from your satellite, then it could have been an answer. But in this case, you yourself are admitting that some software is injected in your system which caused the data breach. So you are directly responsible for it. You can then go and claim indemnification from that third party. Again, you don't have a standing contract with that, so indemnification can't work. But you can again file a case for consequential damages, whoever caused the cyber attack on you. But you can't say as a first person that I'm not responsible for it.
Your Lordship, just to answer your question, I would just like to distinguish between the origin and cause of damages. In the present case, the origin might have been through our satellite. However, we contend that it was not our actions which caused this data breach. There is a clear distinction between the harm that was caused by the data breach which was caused.
So you are
And the
trying to suppose
breach-
there had not been an overlap from your part, right?
Sorry.
There had not been an overlap from your part, right? That is what you are trying to say?
No, Your Lordship, we are just trying to establish that the breach for which they can claim damages under clause 7.1 would be the negligence after or before the force majeure. However, the force majeure event itself, which is a cyber attack, has caused the data leak. Our negligence or after the force majeure event is the resulting blackout. And for those 26-day period blackout, we can compensate them for the value that of the capacity that they have lost. However, the further regulatory hurdles or the PILs that they are claiming for before this court are not direct consequence of our breach or actions.
Please go forward with it.
Yes, Your Worship. If I may just point out one more submission under issue. Your Lordship, in the case of Shipping Corporation versus Bharat Earth Movers, the court had laid down that there must be a proof of actual damage for the parties to even claim compensation. However, the present case, we submit that these claims are premature and have not actualized before any court. If I may move to the players in Wherefore, in light of the arguments advanced and authorities cited, there is I'm sorry. Wherefore, in light of the arguments advanced and authorities cited, we humbly pray that this court may be pleased to firstly hold that the present suit is not maintainable for want of jurisdiction. Secondly, hold that the respondent is not liable for any alleged losses as the blackout of Aurora 5 constitutes a force majeure event under clause 4.2 of the agreement. Thirdly, hold that the respondent did in fact exercise due care and diligence, and that any harm suffered by the petitioner was not a direct or proximate consequence of the respondent's actions. And lastly, to dismiss the claims for damages amounting to 1,500 crores as speculative, remote, and unrecoverable under clause 7.1 of the agreement. If I'm of no further assistance to this court, that concludes our submission.
Thanks.
It was an honor to have you first.
Anybody else? Please, make your point.
Just 1 minute.
Indeed, Your Lordships. Your Lordships, the counsel for the defendant suggested that the principle of dualism is applicable here. However, in the case of Gramophone Company versus Virendra Bahadur Pandey, of which the relevant paragraphs are also present in the compendium presented, it is specified that even without express legislative sanction, it may be interpreted and used, provided they do not run into conflicts with Parliament. Therefore, this is not the right position of law. Secondly, my learned friend on the other side also attempted to rely on Section 28 of the Indian Contract Act, saying that in the express jurisdiction clause, it was laid down that in the express jurisdiction clause, when one of the courts has been given express jurisdiction, it violates Section 28 of the Indian Contract Act. However, Indian Contract Act Section 28 only applies in cases where there is absolute denial in which one party could approach the honorable court, but this is not applicable in this case. Finally, Your Lordships, there is still no response given from their end as to why there was a lack of notice within 24 hours. And even if they did, even if they do contend that the press release amounts to notice, the express clause, as in the capacity lease agreement, was that it suggested that the notice must be given to the other party. Press release is only notice to the world, but not to the other party, and this concludes the submissions from side of the Highly.
Just firstly, regarding Section 28, it was not my submission that the present jurisdiction clause was in violation of Section 28. Rather, it was my submission that Section 28 requirements and the conferment of an exclusive jurisdiction was complied with. However, the inherent jurisdiction, the court did not have inherent jurisdiction, and therefore, for only violation of the third condition, the exclusive jurisdiction clause was there. Now, coming to the dualist theory, it is my submission that in cases where there is absence of any law on that subject matter. For example, this is what happened in the Vishaka case, where there was an absence on law on around sexual harassment at workplace, which is when reference to international treaties was made. But in the present case, there is no dearth of law around damages under the Indian Contract Act, and the petitioners themselves have contended that their claims are contractual and not treaty-based. Therefore, the Indian Contract Act sufficiently provides for the for grant of damages under Section 70, which is unliquidated damages. Therefore, my contention remains that in absence of any enabling legislation, treaty-based claims cannot be adjudicated by this court. And thirdly, regarding lack of notice, the case record is silent on whether any notice was given or not. However, it is also that in Satnet's allegations at paragraph 12 of the case record, nowhere has it been contended that a notice was not given to them. In the present case, therefore, it is our contention that this remains a fact which is not disclosed.
Can you come again to the last part of your submission?
Regarding
it was not stated what you put.
Regarding the requirement of notice, providing notice within 24 hours, it is the fact sheet is silent on whether this notice was given or not. And in addition to that, since all of Satnet's allegations are mentioned in para 12 of the case record, this is not one of the allegations that notice was not given to them. In light of this, it is my humble submission that this court may.
But do you have any reasonable excuse for not giving the notice mandated at the term?
Your Lordship, it is not a matter of fact whether this notice was given or not. The fact sheet remains silent.
If it is not there, that means we presume that it was not happen. Did not happen. If the fact sheet mentions of a press release and does not mention of a notice, that makes us reasonably assume no notice was given rightly.
Your Lordship, in this regard, it is my submission that para 12 of the case record, which lays down allegations of sacred, also do not mention anywhere that no notice was given to them. Therefore, no allegation regarding that has been made by by SACNET in the case record. Therefore, it is my submission that the notice requirement will comply with justice.
Even the maintenance was also not communicated to SATNET that we are going to start a maintenance.
Your Lordship, two-prong answer regarding this. The contract nowhere contemplates us providing them a notice regarding the sale. And second, this maintenance was industry practice, and therefore no requirement of notice, even in an ideal scenario, could have been imposed on my end.
Okay, thank you. Thank you.
Thank you.
Thank you very much.
Thank you.
Thank you.